Thank you, Charlie. Hello, everyone. My name is Tiffany Dayemo. I'll be the moderator for this panel, AI 101. So to begin, I would like to introduce Qudus Olaniran. Qudus Olaniran is a senior corporate counsel at Microsoft in their intellectual property group. Qudus supports Microsoft's gaming and service products on patent portfolio strategy, filing, and management. Prior to joining Microsoft, Qudus practiced as a patent litigation attorney at Orrick, Harrington, and Sutcliffe and Perkins Coie in Silicon Valley. Next, I would like to introduce Collin Smith. Collin Smith is a product counsel supporting Microsoft's 365 engineering and Microsoft's Experiences and Devices organization. A graduate of George Washington University Law School and the United States Military Academy at West Point, Collin previously worked in-house at JP Morgan Chase & Co. and served in the United States Army as both a military attorney and as a logistician. Next, we have LaDale George. LaDale George is a partner at Perkins Coie. He leads the firm's digital health practice. He concentrates on advising innovative healthcare and technology clients on FDA-regulated pharmaceutical and medical devices development and telehealth, telemedicine, teletherapy compliance. LaDale reserves about 10% of his practice time to provide legal services to charitable organizations. Next, we have Robert Uriarte. Robert Uriarte is a partner at Orrick, an IP litigator in their Silicon Valley office, and his practice focuses on software, internet law, and digital crimes. He co-chairs Orrick's Silicon Valley Diversity Committee and is one of the firm-wide facilitators for Orrick's Latinx Affinity Group. And lastly, me. I'm Tiffany Dayemo. I'll be your moderator. I received my JD and Dispute Resolution Certificate from Howard in 2019. I work on various international trade issues, including digital trade, tech issues, and international law. Most recently as a Microsoft Legal Fellow, the second one from Howard from 2019 to 2020, and I'll be continuing that work in the public sector role. So let's begin. Qudus, I'll turn it over to you.
All right, thanks Tiffany, and good morning to everyone. Thanks for having us. This is probably the first time that I've been on a panel with two great attorneys from a firm that I worked at before going in-house, so a unique event. But to get us started, what I'm going to do is I'm just going to try and set a baseline for what AI is. And we understand that the audience, and maybe some of you who are experts in AI, so I don't claim to be an expert, but I do know some things. And so we'll try to set that framework, and then we'll get into the intersectionalities of AI and various aspects of IP and ethics, which my fellow panelists will be talking about. So we can move to the next slide, please. So generally, when most folks talk about AI, really what they're referring to is machine learning there in the middle, which is, most of the techniques that we find today, and that this is borne out by patent filings and with the World Intellectual Property Office, and a different aspect of machine learning that you do see today is deep learning. And so we'll walk through a little bit of this. But machine learning, has various segments to it. And, what I will like to at least, look at is a dimension in which we look at machine learning and artificial intelligence as far as how it's used. And in the next slide, that kind of illustrates the different dimensions of AI. Next slide, please. And so in this, we can think about AI and the techniques that are available. So I've already mentioned machine learning. You have deep learning. You have neural networks that are used in the techniques for generating AI. And then you also have the applications of AI. So one might think, okay, well, we have all these techniques. How would we use them? The applications are in vision, speech, machine translation, search, and so forth. Now, when you have these AI applications, another dimension is what are the fields and where these techniques and applications are used. Productivity, education, healthcare. We'll talk a little bit more about healthcare as we go further along. And then when we then click one down into these techniques of machine learning, next slide, please. we get into, all these various aspects. So you have unsupervised learning, supervised learning, reinforcement learning. What do these mean? Generally, what these techniques for machine learning means is how do you present the data to the model that is going to be your machine learning model? So in an unsupervised learning sense, you provide, can you still stay on the prior slide, please? In unsupervised learning, you don't provide what's called labeled data. You just provide data, and the machine learning model learns for itself, versus supervised learning, where you have labeled data. The model then looks at the label, learns certain things, and does these classifications. And generally, those are used for classifying images and so forth. Versus reinforced learning. Reinforced learning, you don't even provide it with any data at first. It builds up its own data and learns as it goes along the way. So as an example for supervised learning, which is shown on the next slide, you have in a step one, you're providing this labeled data, you're providing to your machine, these are cats, these are cats. And then in the step two, you're provided with a new set of images that are not labeled. And you allow the machine to try to identify, based on what it learned from the labeled data, what are the cats in this image. And so in this case, it will come out cats, no cats. And so these are a typical type of problems that you have a supervised machine learning algorithm type applied to for classification. And if we move on to the next one. And so what I had before was just a demo of what one of Microsoft's Seeing AI apps does. Essentially, this is a form of classification where it looks at an image of someone in the disability realm, which helps this person identify people, identify objects. So you can watch that on your time, and there's a link for the video below. And moving on, a various aspect of AI is data. And this is a quote from Satya, Microsoft CEO, that says a confluence of three breakthroughs: big data, massive computing power, and sophisticated algorithms are really what's driving the growth of AI today. And if you think about this, what that means is that you're going to have concentration of the powers of AI in a few hands because of the massive amount of data that's required, the compute power that's required. It's not just going to be generally available, and the sophistication of the algorithms involved. Further, there's some aspects of AI that are kind of being, more generally available. You're starting to see like facial recognition and so forth. Then, that proliferation creates its own problems as well from an ethics of how do you regulate and monitor it. But that's a different aspect. Again, one of my panelists would talk about some of the issues there. And the next slide, please. And so data being, one of the critical aspects, essentially we see in healthcare, agriculture, accessibility, earth, for sustainability, data is actually very critical for achieving this AI promise. And that's really just showing all the various areas where you could apply this. And if we move to the next slide. With data, the real issue becomes, how can we get more data, and especially data, such that it's not concentrated in these hands, as the issue that I mentioned before. How can we share it freely? How can we share it while addressing privacy concerns? Is it too difficult to share this amount of data? So one of the things initiatives that we try to do here is we have this open data concept. And the way we address this is to say, looking at data, we have to take a different kind of lens to it. If we look at the legal lenses that are available for addressing the data that's out there, you can see that data can be categorized into a couple of buckets. There are these buckets around organizational published data, some research institutions. You have government data that's also published. Some of these will be what we'll generally call open data, fewer IP legal issues around the uses of this data, versus the private data, which you have with companies that you all can imagine are search companies, are companies that sell us all our products, our social networking companies. There's a huge corpus of data that resides in these institutions. And then aside from that, there is the private data of individuals as well. So these are the various different legal lenses that we look at data. And so from a context perspective, on the next slide of where this intersects with AI. And again, I think Robert's going to talk a little bit about this as well from a copyright perspective. You have all these articles and all these countries making, exceptions, because with data, it's the next, next, I guess I would say, next direction in which the economy, it's an economy that's growing and everyone wants to participate. So there are exceptions being made to texts and data mining type scenarios to allow for this promise of AI, for AI to be available to all in general. And so one of this, what this slide shows is just all the various touch points in which we see AI, how it's affecting our lives today. And, this quote around, data is the new oil, it's debatable, but, that is a popular refrain these days. Next slide, please. And so how do we make progress? And I didn't, want to go through each one of these too far in depth, so I don't take up all the time of the panel. But essentially, there are 3 prongs in which we can advance, the access to AI to achieve that promise that I mentioned earlier. It's like we can improve the legal framework for data sharing. We have some sample agreements out there that will allow for the sharing of data between private entities. And we also have technologies that build in trust, such that you can protect the individual, you can protect the proprietary nature of data between companies, and still allow insights to be derived from the data. And then lastly, there's the policy arm, going to governments in Europe and Asia and driving policies that allow for us to be able to tap into the data, make it easier for data to be shared without restrictions, such that we can achieve the promise of AI. Next slide. So, as Tiffany mentioned, I'm a patent attorney, so I had to kind of give a little bit of a patent lens to this as well. One of the difficulties around, AI is, how do you go about patenting this? And some of you who are patent attorneys in the room may have heard things like, people submitting an AI module as AI algorithm as an inventor. This is something that has come before patent offices around the world. Can an algorithm that's been trained, or even a reinforcement learning type technique that builds up its own data, derives insight from the data, can that thing become an inventor? There's a lot of technical, innovative work being done in the AI space, and they generate, these real-world applications. But we, over and over again, I think most patent offices in Europe, in the U.S., and now in Asia, I think it'll be coming up, are going back to that inventor has to be a natural person. And in spite of that, all of these values that the patent provides, there are challenges to actually trying to get a patent around AI innovation. So if you move to the next slide, this shows that, on the AI, with AI algorithms, they're very hard to detect. They are, they fall into this realm of software where, for patent attorneys, or Alice, we have Alice challenges where we're trying to figure out, is this something that's patentable? And then also, where is the innovation for the AI reside? A lot of times, patent attorneys, or at least we see patents these days, where you will get an application that talks about, maybe vision data, and then it says, and a machine learning module takes in this data and produces something. And, could that really be patentable without showing the how of what is being done? And so those are some of the challenges there. And then, various jurisdictional issues between US and Europe, Asia. Again, we have challenges in trying to pursue patent protection for training data, for AI engines, or for the applications and various uses that they have. And if we go to the next slide, and this kind of dovetails into the trade secret aspect of it. Next slide, please. And trade secret, generally, as I mentioned, things are not detectable. So the common wisdom would be, well, let's keep that in-house. No one will be able to detect it. But as time moves on, as you get more compute power, more data, some of the things that previously were undetectable may be detectable through reverse engineering techniques. And so there's always this balance, this tension between what do we keep as a trade secret in the AI realm versus what do we use other intellectual property protections to try to safeguard our innovation. So right now, we tend to lean on the side of patentability on most of our AI developments. And with that, I would just turn it over to Tiffany and Robert to move us ahead.
Thank you so much. Tough act to follow. I'll do my best. So I can have the next slide, please. So the first thing I wanted to talk about are the protectable elements of AI systems. And I tend to think of the elements in three buckets. The first, input, and as Qudus mentioned, data is really key here. I did want to make a distinction between real-world data and synthetic data. So real-world data, just like it sounds, you can actually have a copyrightable data set. The bar for creativity and originality under the leading Supreme Court case is actually quite low. And so we have a picture of a phone book here because this was in the Feist case, the Supreme Court actually held that a phone book, even though people's phone numbers, it was organized in a sufficiently unique way to have protection. So as you think about real world data sets, just be cognizant of the fact that even though it's factual, you might actually have a copyrightable data set. And synthetic data is something that's usually created for the express purpose of facilitating machine learning. And for that reason, there's generally at least some level of creativity and intentional design choice that creates copyrightability. So that's inputs. Then outputs are also potentially copyrightable, and the outputs for AI are incredibly varied. We'll talk about that a little bit in a coming slide. And then obviously the software is copyrightable in the models. So source code, potentially the sequence, structure, and organization of the computer program as distinguished from just the literal code. But algorithms are not copyrightable. And so there's section 103 talks about the idea expression dichotomy. You can't have a copyright on an idea. You can only have copyright on a unique expression. And so you might have a model that has a bunch of algorithms that are not copyrightable, but those algorithms. Next slide, please. So looking at inputs a little bit more in depth. So as I mentioned, compilations of uncopyrightable facts can be copyrightable. There's a synthetic mass data set that is basically all synthesized patient records. So those records really contain only facts about patients, but the data is organized in such a way that it's usable and it's structured so that people who want to use that data set can actually take value from it. And so that complex structure is probably enough to make that data set copyrightable. If you drill down and look at what are the data elements themselves, I thought this picture here is a good example of an input that is copyrightable, right? So this is a photograph that was generated using a synthetic scanning electron microscope. And so clearly this photograph is copyrightable. However, this data set also includes a JSON file that's pretty flat. It just lists the size of particles and their position. And so there's part of this data set contains copyrightable content, but the part that's really being used by researchers and ingested is a relatively flat JSON file that probably is not copyrightable. So sometimes you might have to do a little bit of parsing if you're trying to understand what are the risks of using the data. You might have to think about which parts of the data set are we using and for what purpose. And then the last thing I'll mention on input is that structure is really key. And so if you have a data set that's very flat, like a binary pair for recognition learning that Qudus was talking about, so photo of an apple and an apple, those two data elements are probably not enough to create copyright protection. But there is, if you go to look at a data set that has a lot more structure, it is going to be copyrightable. So for example, there's a case involving Experian that held that the consumer credit database format was protectable. And so just think about, as you go through the real world and you're trying to assess risk, how structured is the data that we're looking at. Next slide, please. And then the outputs can also be copyrightable. So some of you may know about the GPT-3 machine learning program that is generating blog posts, and they're actually, it's kind of funny. I would encourage everyone to go read a couple of the blog posts. I think you'll be surprised at how human-like this AI program is. And so those blog posts are literary works that are potentially subject to copyright protection. My favorite example is The Next Rembrandt. Please go watch that video. It's just like a 5-minute video on this project. But it was really fascinating. Researchers looked at a bunch of different Rembrandt paintings, and they did a number of types of analysis looking at how the relationship between different facial elements, the thickness of paint. I mean, it was really incredibly in depth. And they created this data set that allowed them to then create a model to produce a painting today that looks like something Rembrandt would have painted. And so I think this is a good example of an output that is potentially copyrightable. It's an artistic work. It's kind of core copyright content, but it's created by a computer. There is some case law that says that the owner of a copyrightable computer program can own the output of that program if the program is kind of doing the lion's share of the work. And so I think this is sort of the next frontier for copyright, is to what extent AI generated content is copyrightable. It's a really interesting issue. And then another output of AI is potentially just an improved model. And you may have a model that starts off as doing one thing, but after being trained on data sets is doing something different. The model changes. And that change is potentially presents some copyright risk, because if you can imagine a data set that's so incredibly structured and it's copyright protected that by training your model on that data, your model actually becomes a sort of derivative work. And so if you think of it in the context of this Rembrandt data set, for example, if I were to use that data set to go create a new model to generate portraits, there would be a lot of similarities between my model and the next Rembrandt model. And so it creates a potential derivative work issue. Next slide, please. And then just briefly, I wanted to talk about other issues that are kind of tangential to the copyrightability point. So fair use is already a very tricky doctrine. I think it's going to be even more tricky to apply it in the context of some of these emerging AI issues. In general, I think if you're using a synthetic data set or a data set that was created expressly for the purpose of training AI, it's hard to make an unlicensed use of that data set and then claim fair use. On the other hand, if you're doing something like I have a screenshot here of the not safe for work filter, and I suspect that in training this algorithm, the creators went and just pulled a bunch of images off Google, and so there's potentially some copying that could create liability because you're making copies of artistic works. But on the other hand, the purpose of that copying is entirely unique from what the artists intended their work to be used for. So it is probably sufficiently transformational to be a fair use. And then the last point before I turn it over is think about data acquisition issues. So there are a lot of different types of barriers to acquisition that can implicate sort of copyright adjacent issues. So the DMCA, for example, prohibits circumvention of access controls. There are also copyright management information issues if you're pulling a bunch of data, pulling a bunch of images to train an algorithm. There are potentially computer trespass issues under the Computer Fraud and Abuse Act and state analogs. And then there are also common law and statutory misappropriation issues subject to copyright preemption, but you may be getting into trouble if you're taking data without authorization. There could be state laws and statutes that create some liability there. So with that, I will turn it over.
Good morning, everyone. This is LaDale George. I'm going to talk to you about AI in healthcare. And I appreciate that many of you as law students are trying to decide, where are you going with your careers, how you're learning in the law. And I'd invite you to seriously think about as technology operates forward, and if you're looking at a legal career in technology, that you look at healthcare as a place for that to occur. Often in the law, we deal often with how something works or why something works. I think within healthcare, it's extremely relevant to understand that it's kind of the so what. So what of all that? What's the real relevance here? And the relevance in healthcare is it's completely applicable to you as a human being. And in all aspects, and in the aspect of what's most important, which is your life. And I think this year of dealing with the pandemic and seeing how impactful the world of healthcare is to our just very everyday existence is quite relevant. So it's the so what that has kind of driven me and kept me in the area of looking at healthcare. Shout out to everyone at Howard. We have enjoyed coming to you for the last 2 years in person and this year virtually. So it's always a joy to be back at your school. And to my original professor, Professor Ziad Matalo, who's there, a Constitution professor. I was his first student when he was a graduate student. So it's always great to come back and visit with him. I'm going to talk about AI as it relates to healthcare. And what's important in the conversations come so far this morning is the need for data as it drives AI. And AI, its real importance here, the so what is, it's capable of analyzing, learning, and drawing predictive insight from large pools of data. And this is important both in the here and now and in the future. So for both precision medicine, personalizing medicine, and then augmenting the decision-making of healthcare professionals as decision support. What that means with the here and now is if a doctor is using an AI technology, they may be evaluating a presence of whether or not someone has cancer. Typically, if you're looking at analyzing information that a doctor would evaluate, it would be a radiology scan, it would be blood work, and a doctor is trying to evaluate whether or not what they're seeing is cancer, and they're basing it on their own level of learning and their collegial work of those around them. AI provides the ability to use large pools of data, globally in nature, pools of data that help them to more clearly analyze what's in front of them. In the future is the predictive. Where does this take us? So with doctors able to sort of, what's the prognosis of this patient going forward? Again, previously relying on that doctor's understanding, relying on the understanding of their colleagues who may be in the room. The predictive nature of AI will allow you to use large pools of data to help predict and identify and reduce unnecessary tests that may be in the future, ineffective treatments, a number of different predictive events that can be used, that AI may be used for. AI was important in looking at the predictive events of disease outbreak. A tremendous amount of modeling into the COVID-19 pandemic was based on AI technology, seeing what the origin is, what the level of spread. Once there was some understanding that this was airborne as opposed to surface spread, then it becomes a modeling of looking at all of the data that we have for airborne spread. What's the predictability of where this disease is going to go, and what behavior do people engage in where we see large expanses in that infection rate increases. This is what AI technology has been used for in the area of healthcare. The resultant learning is some really real-time collaborative evaluation by medical and scientific professionals and validating prior clinical applications, looking at and understanding how healthcare has been provided in the past, using AI with large pools of data, analyzing and providing predictives in the future, really can be integrated into healthcare to support medical decision-making by the clinician. Next slide, please. The presence of AI, though, does present some risk in healthcare, and it's things that we should be, quite mindful of. One is that the availability of health data pools is not universally representative of the full spectrum of those affected by disease, which also means it may be based on some social bias. So all data has not been collected the same way. Whether you can go to 20 different hospitals in the United States, they may be on 20 different electronic medical record systems, and they all may be capturing data differently. Well, when you dump all of that into a pool, what you captured in a data field may be something different than someone else captured in a data field. So getting data that is uniform, consistent, then makes it reliable once you start building your AI models on that. Evaluating learning and adaptive tools cannot be validated under the current regulatory schemes that require fixed products. This is a huge challenge for the FDA. Recently, the FDA, about a month ago, released an action paper saying how the FDA is going to start to work with AI on the adaptive side. Historically, the AI, and I'll go to the slide that's going to come to this, showing what FDA has approved in products so far. And they've all been on locked models. And a locked model is where you use AI technology, but there's no machine learning that's taking place that's changing the output of that AI. So the FDA is now, because you needed a fixed product. You want products, once they get approved by the FDA, to be consistent, reliable, so that when they're used, they operate the same way every time. Going forward, what AI and machine learning provide is a model that is going to improve itself, potentially, by continued use. There's no regulatory scheme right now that allows for products to enter the market where they will be different than what was approved at the regulatory phase. So these are things that need to be adjusted. Looking at the cost of diagnosis and treatment, do they disadvantage different populations and societies is going to be a question that we have to deal with AI. Looking at a lack of transparency on understanding the functionality of these algorithms is going to put pressure and will be putting pressure on our liability system. Whether or not there was negligence in the performance of this service when a predictive model was used, but you really aren't able to get underneath and understand. There's a lack of transparency in understanding how that AI model works to really evaluate whether negligence was even present. And then, of course, the privacy and security issues, very sensitive to individuals, very sensitive to governments and societies around the world. Unfortunately, we saw that in the pandemic. Next slide, please. What's in front of you is a very scattered screen of what the history of particularly the FDA has been with AI and machine learning. Since 2014, the FDA has been approving AI-based technology. And this is software that's used in medical devices or medical devices that are actually software themselves. Going since 2014 to the end of 2019. And you can see, if you look in the middle, where the bulk of the activity is in the area of radiology. Say, well, why would it be in the area of radiology? Because radiology uses images. And if you can use a pooled set of huge data sets of images and then try and distill down what separates a tumor that is of a certain size and dimension or density on that image, and then be able to predict from there whether or not this is going to lead to cancer or something of that nature. That's why AI has been such an incredible tool and will be an incredible tool in healthcare. So I ask you, as you consider your careers and looking at technology, healthcare is an incredibly broad and relevant frontier and applications for AI. So if you're looking at technology in the law, think healthcare. And then I'll pass the slide.
Thanks, LaDale. Morning, everybody. Collin Smith here. I'm going to talk a little bit about our legal ramifications and considerations when it comes to enterprise data. And so we got a really great summary early on with folks talking about the overarching kind of themes and kind of that can kind of control the discussion and everything around AI. I'm going to talk a little bit more practical application. And some of these things might lead a little bit into some of our discussion about for our overall panel in the Q&A about our day-to-day and how we see how it impacts the matters that we handle on a day-to-day basis. But this will be a good, maybe a good primer for that. So the first slide here that we have is a couple of definitions from Article 4 of GDPR, which are two of the main words or definitions that are and should be top of mind in consideration when if you are practicing in this space. One is processing, which is the key thing. Any kind of the way that data is handled, transferred, the way that data flows through a system or software is kind of generally under the definition of processing. Profiling or monitoring, something that we're seeing is becoming increasingly important. This is one area that governments, particularly here in the EU, obviously, and then other governments around the world are starting to take a very hard look at to see if there needs to be any additional regulation around how AI and machine learning models can potentially profile people or can be used in a manner that is monitoring or could be considered monitoring. For example, we'll give one real world example in Finland. There is a law that essentially, as far as any kind of analytics software that could be considered remotely monitoring, is essentially fundamentally illegal in country. So let's move to the next slide, which will be interesting from Qudus's slide earlier with the news headline that said that it's debatable or that it's not. I'm gonna posit to the group that data is indeed the new oil. Maybe not so much as what that article is what I assume is trying to say, which is that economically that it's the new oil. But if you're building a new spacecraft, if you're building a plane, train, or automobile, you need some gas in order to make sure that thing can run. That oil or that data is what's going to make your AI machine learning model and software run. So let's go to the next slide. So with that in mind, just some of the general challenges and considerations. And once again, when we get to the Q&A, I'd be happy to dive in a little bit on these. The number one thing, obviously, is if you're a customer or your client, need to understand whether they are the data controller or the data processor. For those who might be familiar with data controller or data processor, it seems like this might be a pretty simple distinction for folks to make. But sometimes the customers or clients don't quite understand what their obligations are in that regard, depending upon which side of that dichotomy they fall on. A couple other things, access to training data, derivative use, contractual obligations, and all these things kind of work together. So access to training data is something that everybody's been talking about during this panel since the beginning. We sometimes the way that I like to classify them is you have first party training data, and so that's going to be as that data controller. For example, Microsoft, we have access to first party training data, and that would be all of our own corporate data. The obligations are very different versus whether you're using your own first party data or if you're seeking to use third party publicly available data or third party license restricted data. Those are the two where if you are working with a client customer who is developing AI models or machine learning models, developing new software, the data corpus that we've been talking about also, this is where it starts to become where that data is indeed that oil that we're talking about. Without the training data, your AI machine learning model is unfortunately not going to learn a lot, not going to end up being very intelligent. Publicly available third-party data is a lot easier to obtain. Oftentimes, it'll come with a license, a use license or a grant that is makes it pretty much falls within that open data or open data initiative that we talked about. There might be a few restrictions here and there around some of the derivative uses. For example, you might only be able to use that data for one particular purpose, even though it's free and publicly available. And they might also place some restrictions or just attribution requirements around derivative use or any other development therein if you decide to use their data set. Third-party license restricted data is a lot more difficult. This is one that I think is one of the things that is, if we're talking about growth of AI, this is one of the things that is has the ability to slow that growth. A lot of, as we said, with it being potentially the new oil or debatably the new oil, when a third party has access to a large data corpus, and this is a part where if we were all in the same room, I would ask who in the room, raise your hand if you've heard of Reddit, for example. An entity like Reddit has millions, if not billions, of comments in a variety of languages that they have and that they own, only available through their own API, subject to their use restrictions and their terms of use and license. Something like that is incredibly valuable for software engineers and developers in the world who are trying to make advancements in training their machine learning models. Because once again, that model is only as good as the data that you train it on. Another consideration or challenge is derivative use, and whether your customer or client has authorization to take essentially make derivative works from the initial pass on that training data. Oftentimes, the person or the entity that provides a data set for training will provide that subject to the restriction that it's only intended for the persons of which their purpose of which they're licensing it to you for. So you could use an example of maybe a predictive text model that can try to predict your email as you're typing it so that you can get through it really quickly and fire those emails off. They might say, yes, company A, you can use this data set to help develop your predictive text model for email and then nothing else after that. And so you basically then are sitting on a massive and potentially valuable set of data that you can't use for anything other than that one particular AI machine learning model. And then the last one that, or not the last one, but we'll move on, talk about contractual obligations. Sometimes in places where the law or regulation might be somewhat ambiguous, and we can point to our own country here in the United States that does not necessarily have a very robust federal regulation or law similar to the EU's GDPR. Sometimes it can come down to what did the client or the customer agree to. If they agreed in writing that the data that is collected as a part of some sort of engagement can be then repurposed and used for AI machine learning purposes or other software development purposes, that's one area where you can reduce some of the friction and get some potentially valuable data for your engineers. And then also, what did the data processor commit to on the other end of that? And so for that person providing that data to the processor to do something with for them or provide a service, the processor is in taking hold of that data and committing to protect it, also might make certain commitments to that customer or that client and say, hey, we're only going to use this for an AI machine learning model that we're gonna then make available only to you, or we're going to use it for limited AI development purposes, but there'll be a certain level of pseudonymization, anonymization, or de-identification of the data, essentially a scrub of the data, to ensure that it only contains the corporate titles of the people that of the list that you provided us for one example. And then the last challenge and consideration is we're talking a little bit more in that gray area as well, and we'll talk about this next too, is ethics. And so with that, I want to go to the next slide, which there are risks and rewards to consider for the ramifications of AI. And this goes to the ethics too. And right here I have two headlines from Forbes. These headlines are about 3 months apart. You can see the difference in how people are looking at it and how they're talking about AI. On the one we have, is it dangerous? And here are 6 risks to think about. We could probably, think about a lot of what those risks are, whether it's, like the one on the right, racial disparities and racial inequity, or other risks and potential pitfalls. And then on the other side, you see there how AI can help to remedy racial disparities in healthcare. To go back to LaDale's discussion about healthcare, and so a lot of different risks, really good potential rewards, and the question that that I will leave with here before we move to our next part, when we're talking about ramifications AI, is there are a lot of things that we can do, but should we do them? And with that, I will turn it over, I think, to Tiffany.
Great. Well, thank you, Collin. I appreciate that. So just in the interest of time, I think we'll go ahead to the Q&A. But the first question I wanted to pose to the panel was, what legal issues are you seeing coming up in your day-to-day practice concerning AI, particularly in ethics and bias, inclusiveness, transparency, fairness, and privacy?
Hi, thanks. So as someone who's focused on copyright and computer trespass issues, one of the things that clients are are asking for a lot of help on is figuring out what they can do with respect to data acquisition. So people are looking to get data sets, and they're looking to ensure that if they're getting data or models that are available either under an open source license or just publicly available, that their use of that material doesn't infect downstream products. So it's looking a little bit at copyright and looking a little bit at some of the data protection statutes. That's probably the #1 issue I'm seeing these days.
Yeah, going just right back to what I was just talking about. For me, it's licensing those third-party data sets. You know, the AI is very powerful, but it's only, like I said, only as powerful as the training data that you can feed it. And even large data sets, one large data set is still not enough to be able to get AI in a place where, particularly you're talking about something that's customer facing, that, you know, an end user is going to use, like the predictive text model that I highlighted. It's not going to function in a manner that an end user sitting at their computer at work is going to expect if it doesn't have the requisite amount of data in order to get that trained up. And increasingly, I'm seeing at least that a lot of the third-party data sets that are very good data sets that don't have, I see some comments there talking about bias, for example. One of the problems too is that some of the data sets do have a lot of implicit bias built into them. You know, you think about something like I said, a Reddit comment database. The amount of racial slurs and something like that is probably otherworldly. And so some of those data sets that are contaminated, it's becoming more and more difficult to obtain good data for free or you know, open that can be used for training purposes.
I guess,
go ahead, please.
If I may add to that, I think, you know, I work with engineering teams, and, you know, so access to data certainly is one of the things that's a big concern for them, and also the diversity of the data that they have available to be able to train different models. You know, some of the, you know, and I think as I described earlier, you know, you have stuff that's labeled data, and then you have, you know, the you know, unsupervised learning where, you know, you're just trying to find patterns. And so the larger the data set is, the more patterns and insights you can derive from the data, and also the compute aspect. One thing, I guess, there's a question in the chat around bias, and I recently read an article that talked about the AI, you know, people getting PhDs in AI, and, you know, that has, you know, moved and increased over the years, but there's a disproportionate amount of, you know, if you compare African American to white PhD, and I think it's some of the order of, you know, there's an order of magnitude difference. It's like 45% AI degrees in PhD degrees are going to white researchers versus 2% to Black. And so these things also have the downstream effect of, you know, not just on the input data, but how, and, you know, you train the models and what insights you're trying to derive and what you disqualify as being an appropriate outcome from the models that we're using.
And one of the issues that we are dealing with in healthcare is the quality of the data and what that leads to. Again, going back to my point of the so what. And I'll make this real practical, vaccine allocation for COVID-19. Not only when you're looking at the factors of where vaccines should be allocated, I mean, where do we send the vials for people? Data sets were used to try and model where those vaccines should go. Some of the information in that data set was based on what is historically biased, not necessarily historic, but historic disparities in healthcare. So we looked at vaccine administration for normal, for just the flu. There is a greater utilization of flu vaccines by some populations than others in the United States. We looked at, and that's both urban and rural in application. We looked at historic data on where people are more likely to go to the hospital for certain services. And what you find is there's a greater utilization of healthcare among non-minorities in the United States. So people who are white use healthcare services greater. So if you use that data, throw it in your AI, what happens is it starts shifting your model towards, we need to provide greater allocation of vaccine in these communities that have higher utilization of healthcare services because they look more in need. Well, that's not accurate in reality. Reality is the communities where there has been lower utilization that needed more allocation, because that's where people were getting sicker and dying quicker, but spending less time using healthcare resources. So there's a lot of disparity that can take place if you start using old data that didn't take into consideration certain biases.
Thank you all for those insightful answers. I see there is another question from Jason Lynch, who asks, how does the panel think about liability, tort, and criminal for users and creators of AI ML technology?
So at least as I understand that question, it's really looking at what are the consequences to a creator when AI goes bad. And I think we can just, at least on the tort side, apply the traditional framework for foreseeability and responsibility. I think that works. And the criminal side, I think it's a little bit more difficult. As a crim pro junkie, like, I'm thinking of all of the mens rea issues that come up, and how do you attribute intent that might have been machine generated intent to the person who created the program. So I guess it's somewhat of a foreseeability issue, but I have a little bit of hesitancy to lock someone up because of what their AI did, unless it's really clear. So that's a great question, and something that I think we'll need to really think hard about as a profession.
I'll say on the healthcare liability side, this is a real issue, because healthcare liability, medical malpractice, has always been based on a theory of negligence. If you didn't provide the standard of care, you were negligent, therefore liable for the harm that was the resulting to the patient. The challenge with AI presents is, if you develop modeling and the predictive says that you should use a particular treatment, and the doctor says, I don't think that's the right treatment to use, and then there was a negative consequence to the patient, then the doctor is going to be held up in court against the standard of, well, the machine told you to do this, and you didn't do it. So therefore, that then becomes potentially the new standard of care. On the other side, if the machine says, well, you should amputate, but there was reasonable basis for why amputation was not the right direction to go, then is the doctor then to have a shield by saying, well, the machine told me to do it? So it really is going to have a very deep ethical conversation on where liability should be evaluated for AI use in healthcare decision making, particularly as it relates to medical malpractice liability.
Thank you. So as we get more questions, I have a question for the panel. Can artificial intelligence infringe on certain rights?
Yeah, I think so. And actually, one of my partners handled a case recently that involved this very issue, because the defendant had artificial intelligence that was selecting images and then displaying them on a site. And they tried to, the defendant basically tried to say there was no volitional conduct by the company. This is just our AI program that was selecting and displaying these images. And that defense didn't really fly, at least at the motion to dismiss phase. So the case was resolved. But I do think that if you're creating a program and it's infringing, and you have control over it, and you had reason to know it was going to infringe, then it seems fair to me to hold you accountable.
Thanks, Robert.
Sorry, I wanted to add to I think what Robert was saying there around the question of, can AI infringe? I think it depends. It depends on in the different realms of IP that's available, whether it's from a patent perspective versus copyright. If you're talking about the use of AI in certain applications, then the elements of proof are looking at the claims of a patent, for example. And so when you say, can AI infringe, is it the use of AI in an application? So let's say vision detection, for vision or speech, natural language processing. Depending on what the actual application is doing, if it's an AI-based application, it could very well infringe because the models are really just, the inputs in that it's taken and then what outputs or classification that it does on the output. So one will have to really look at the claims of a patent. Similarly, same type of analysis will probably be involved with trade secret as well. So that, again, it's not a satisfying answer, but it kind of depends.
Thank you. Okay, so I see a few questions coming in. So I have a question from Timothy Buckley. Has it been more difficult to enforce Microsoft's AI-related patents versus your more standard traditional patents?
That one's a little bit tougher question to answer in the sense that we generally, Microsoft has not been an asserter of patents. We do have a large, patent portfolio, but we're not really going out there trying to assert our patents. So to do a comparison between our AI-based or machine learning-based patents as against, non-machine learning-based patents is a difficult analysis to do. But I think during my section I talked about the detectability issue. So when you have patents, if they're either directed towards techniques versus application, on the technique side for neural nets or other algorithm-based innovation, it's really difficult to tell if someone is doing exactly the same thing because again, the patent analysis is on a claim-by-claim basis, and each element of a claim must be proved up. So the detectability of use is very difficult. Now, on the application side, it may be a little bit easier. I would not, say one way or the other that our AI patents are more enforceable than traditional ones because patent litigation in general is difficult. Anyone who's involved knows, there's a lot of stuff that has to be proved up, and a lot of those cases really don't go to trial because of all the challenges involved.
Okay, thank you. And I think we have one more question, time for one more question. Tessa Gray asks, would explainable AI be a better alternative to commercial use to deal with discrimination issues? Are there any statutory requirements for explainable AI in the US? This is from, she's a student.
Crickets. I'm not I'm not aware of. Okay. So I don't know if anybody else on the panel is going to take this, but I'm not aware of such a statutory requirement for explainable AI. I mean, I imagine that with all the proprietary stuff that companies are doing to have the leg up on the competition, this would be very difficult to enforce in and of itself.
Yeah, I mean, in the U.S., I mean, we don't, probably the closest thing that we have to a statute that starts to approach an attempt to regulate AI would be maybe the Illinois biometric statute. Even the GDPR doesn't tend to, at the time, at least at this time, is not reaching super far into the world of AI when it comes to regulation. But yeah, in the U.S., that's definitely one of the challenges, that I'm seeing, and I'm sure Qudus is seeing, and everybody on the panel is seeing, is that there's a lot of gray when it comes to regulating AI, and so trying to balance the we can do this, but should we do this question is something that's becoming, can be increasingly difficult to explain to certain engineering groups or other companies that are attempting to, develop a lot of really cool AI machine learning applications today.
I encourage you to go take a look at the FDA's website and just search under AI. 2 years ago, they put out a discussion document to try and ask the community about distinguishing between locked AI and adaptive AI because of the issue of moving from fixed modeling to a fixed product to a mobile or adaptable product. So the FDA is struggling with this issue of how to regulate it because it's showing up in the healthcare world, and it will be regulated in some manner. So I actually invite you to take a look at the action documents that the FDA has put forth, because they talk about a model of encouraging companies to provide a roadmap of what they believe the change in your AI or machine learning is going to lead to. And if you're supporting data that shows you're moving along that positive track, your product may be able to stay on the market. If it shows deviation from that track, there may be reevaluation by the FDA. So I would say the FDA is moving real close to some regulation in this area.
Can I jump in here? I just want to give you all a round of applause, and I'd ask everyone else to join me. If you don't know the icon, it's at the top. It would take our patent AI group to kind of go over time, but love you all. That is great information. I love the way you weaved in information for the students, and then we really got technical and deep for the professionals. And I just want to point out that question that kind of had everybody sitting there stumped, that came from a Howard Law student about the alternative, Tessa Gray. So great job. I want to make sure people get a break. Of course, you could take your cameras off and get a break at any time, but our next panel is getting ready. I just want to thank you all. You did a marvelous job, very engaging, and you can tell I'm not gassing by the number of questions that you had. You even had some comments going back and forth. So I encourage you all to check that out. And Collin, you said a best practice for all of our panelists. If you could put your LinkedIn link into the chat box and let people know where they can connect with you. Thank you all. Marvelous job. You got a break. 10:05. We'll be back here.